Angi introduced, I am Deepa, the Deputy Manager Policy at DSCI, and now we are joining in together for a session on privacy jurisprudence in India, a look at DPB and everything in between. So the question that why we have named the session as privacy jurisprudence is for the reason that compared to other jurisdictions of the world, the privacy regime in India is still at a very nascent stage, wherein we are making legal developments around different sort of bills and coming up with different consultations. So, in this regard, we are faced with faced with the challenge of balancing an individual interest of privacy, and on the other hand, we have to balance the expectations of business and digitization in that regard. So in order to deal better with it, we have eminent set of panelists today with us who will be helping us to understand the jurisprudence in India as to how privacy regime in India has evolved since Puttaswamy judgment and how far we have come in our privacy journey as compared to other jurisdictions of the world. What are the key takeaways that we can borrow from rest of the world, and what are the major things in which we can show ways to other jurisdictions of the world in standing out ahead from the other jurisdictions. So, in the paucity of the time, we are still awaiting our fourth panelist, but I will start with the session and would ask first question to Mr. Rajesh as to what is the privacy culture in Indian context? Like, how do we see privacy and visualize privacy in Indian? So we would start with the discussion, as in the primary focus of this session is to discuss the nuances of the three bills that we have, basically the Digital Data Protection Bill, the Telecom Bill, and the expected Digital India Act, which is soon to come out for public consultations. So we as an industry want to see that how do we balance the expectations around privacy, individual privacy, and the need for having digitization, emerging technologies, efficiencies around those technologies, how as an industry or as a regulator or as a member from legal fraternity, what do we expect our government to do in that regard? And that is why the session is designed in such a manner that we would be having questions around these issues to deliberate and to see what are the expectations and how can regulation meet those expectations in that regard. So to set the ball in motion, I would ask the first question to Mr. Rajesh that, sir, what is the privacy expectations or culture around in our country, and what problem as a regulator it faces when they are framing some legislation around privacy for a country like India, where we have diverse set of expectations from government on the issues of privacy and digitization for that matter?
Thank you, Deepa, for the. Just to introduce myself, I am Rajesh. I'm from Infosys Data Privacy Office, which means some of my thoughts would have already been spoken by Srinivas Pusrilla. So I've learned from him. He is my mentor. So probably I will try my best to do my job to deviate from that and try to put better examples. So see, privacy, if you look at India as a culture, right? Privacy is very much in the nascent stage because we are not a community who have been existing the culture where we restrict information, because we have lived in communities, families, joint families, where more and more important there is a necessity for information to flow. Okay, but I think with the pace of digital evolution that has happened, and internet revolution with mobiles and other things coming into picture, I think it's slowly catching up to a certain extent, pretty much in terms of where privacy is equated towards security. And that's where you see much of a challenge that is expected as, we see a lot of papers written on utility based and security related requirements. So culture still is in a very nascent stage. The expectation what a user needs to have, to rightly understand what privacy is. Because privacy is more about rights that is available to an individual to exercise, not to be bothered or to be let alone, and to make its own choice of decisions. I mean, that is more from a legal. We even see that even also from the Consumer Protection Act, even though it was the old act was 1988 based, but you see the Jagran Mukti Mocha and all those concepts of advertisement started coming in just 4-5 years back. Emphasizing the need of or importance of what rights a consumer has under the law to protect, right? So I think privacy is an evolving phase. You have got much attention only in the entrepreneurial place. Because one, we have organizations in the country which, being an outsourcing industry sector, is trying to meet the requirements of many clients who are from outside, where the law is already matured enough, and that gets translated into through a contractual obligations on us. So that puts us a much more from a compliance forte where you can. So it is divided sectionally. I mean, corporates has a very different perspective. You have new startups coming in, their approach and their expectations is very different. And then you have the rural side of the population who doesn't understand anything about the privacy. Okay, so there are different commodities, and still, if you look at from a maturity standpoint, we are very much at the nascent stage. We have to evolve, and this is one of the reasons why the Indian IT rules 2011 also failed, because one, there was a lack of enforcement, but other side, the most important is the citizens or data subjects or data principals we call, they were not aware of what the rights were. You still had the rights in the IT2 rule 2011, but unfortunately there was no serious emphasis on understanding what is it more all about. So I think that's from a cultural standpoint, we are in the a way forward, and we can look at somewhere close to around in the next 10 to 15 years to gain some kind of maturity across the country. Probably the cyber crimes and other threats can increase the awareness of each individuals to understand what really privacy means for them as a society, and then probably can catch up to the pace.
Rightfully, like I was also I was also having this apprehension that regulators, they are coming with a fourth iteration of the bill, from a comprehensive set of legislation to a just crisp 24 pages legislation. So in that context, in order to make it crisp, I would like to ask from Om, like, do you feel that it is a good idea to not have a prescriptive legislation and have some like principle based legislation, which they are claiming that it is, and like does it give you flexibility and certainties in your business production or for your business purposes, or we need to have more prescriptive legislation to be having some sort of certainty for business requirements?
I hope I'm audible. Yeah. So thank you, Deepa. Firstly, whatever the views I'm sharing are more personal rather than the stand taken by my firm. And not audible. Yeah. Is this? Can you close an RFID? It's making a lot of noise. Yeah. Done. Thank you. So my views are, in a country like India, where you openly declare your caste, is your caste aligned to a religion? Okay, where there are certain religion biases which are inherent in our society. Also, I would talk about your political preference. In some places, you declaring your political preference will not have an impact. But in some places, you could lose your life if you are having a certain political preference. So the term constitution of the word privacy, what we are trying to do is replicate what is there in the West and in Europe. It stems from there. What is privacy for us Indians, is something which is missing.
Yeah.
And I think that is what the basis of just a 24-page bill, because you can't keep on defining in details a lot of things because it has multiple implications. Just a outsider view or non-tech view on that side. Secondly, in terms of getting into detailed specifications, one, these structures are not clear. The industrial bodies now have to adopt and be more open as to what is privacy data when you're collecting data for banks. I saw a lot of DSCI doing a good work in terms of sharing certain frameworks as to what constitute privacy in healthcare,
Yeah.
and I think they're coming up with the banking stuff. But then these are the things which industry bodies have to adopt proactively, set these definitions in place so that the privacy by design is more successful. Okay, we being socially very different, linguistically very different, our objectives and thoughts differ vary from person to person. And in this plurality, I would say there is a unification which is there. So my concept of getting into the privacy definition is something which needs to be defined when we are adopting tech services, okay, and then getting deeper, because within India things get hazier. The only thing what I want to also add is when data started getting collected, and then you have a lot of global players where internet starting getting connected, a lot of global services will come into play, and a lot of privacy related data got captured. That is where we thought that there is a need for a privacy database. So I would, look into not for more from a DPO perspective, but we need to think that India is really different, and we need to have a structured approach which is different what has been adopted globally.
Yeah, so basically there is a correct approach you are saying that we are drifting away from this European model which gives us sort of very prescriptive sort of legislation with regard to everything, be it notice, processing. So we have our principle based approach in our given legislation. So Shashank or Jaideep, like I would like to ask your intervention in that regard, that how do you see that our shifting away from European model and coming about to Asian and Pacific region is helping us with regard to framing these policies around data governance and personal data? So, what are your take on that? Like, if I am remembering correctly, our legislation has adopted certain concept from Singaporean legislation, and Singapore is somewhat have some similar culture like India. So, what are your views on that? Like, are we going around the correct approach? What is the regulators intentions behind this, that we are drifting away from that European model of data protection and privacy?
May I take? Thanks, Deepa, for that question, and thanks, DSCI and ASCOM for providing this opportunity for this panel. Very quickly, and I didn't think that I would be commenting on this, so slightly my thoughts over the top. I would like to slightly disagree with my co-panelists here. I think the Supreme Court of India has been very crystal clear in what privacy is. It's re-articulated the sort of expansive nature of privacy in India, informational privacy being one aspect. Although I would agree on one point that my co-panelists have made, that expectation of privacy in India is slightly different as compared to some Western nations. Although I would sort of say that what I share with my family, the expectation of privacy is different vis-a-vis what I share with the corporate. I don't think we want to go into a situation where our data is leaked to certain foreign actors and they sort of misuse, and we'll have some democratic and political environment that is unconducive to us. So I think I would really like to draw that distinction, that privacy is not a Western notion. In fact, there's academic literature on this from India, from rural India, that says that always there's a point at which everyone stops selling their own data. For rural, this study was done in Himachal Pradesh for rural women, and at one point in the study, they said, for whatever money you give me, I will not share this data. So just wanted to sort of quickly make that point. I don't think we want to be compared to Singapore. I don't think Singapore is a mature enough democracy like India. I think our constitution and our historic democratic history is much richer. So I'll keep it at that. But I'll definitely say that there were certain principles that were adopted which are universally recognized, which were adopted in the previous iterations of India's data protection bill, which unfortunately have been sort of dropped, or we don't see them anymore. In fact, we have, as CCG and New Delhi, made our submissions to the ministry public, and we have pointed out to one factor that universally recognized data protection principles like purpose limitation, data minimization, storage limitation, although some of its effect we can see in our DPDP bill. They are not explicitly mentioned in the bill, and we made a recommendation to the ministry that please you ensure that these sort of phrases are mentioned in the bill. We can adopt language that is already drafted and present with us in the form of previous iterations. So I definitely feel there's some dilution. I would want to revisit what Mr. Gupta's presentation was earlier as a keynote speaker. He also mentioned that there's certain specificity that's lost in our bill in the sort of garb of simplicity. I think we're treading in a bit of a tricky, on a tricky bridge there. I hope we don't fall from there, because it is in a technical subject area like data protection, you need some specificity in the bill. So I sort of leave my comments and pass it on to Jaideep.
Hi everyone, good to be here. I work in Trilegal's technology, media and tech team. again, I'll give the same disclaimer that these are my views and not those of the firm necessarily. As far as the draft bill is concerned, I think I'll comment from a legal practitioner's perspective. Because it has taken a fresh approach and not necessarily imported certain terms, it can be seen from a good and maybe not so good perspective, because we lose the interpretative guidance that comes through the GDPR authorities and the GDPR jurisprudence, which may evolve. For instance, terms like personal data have now been defined differently. Also, the provisions on cross-border transfers of data. There's a big question in the industry as to whether only data fiduciaries can transfer data abroad to the notified countries. Is it applicable only to them, or if a data principal gives their data to a foreign entity, does the transfer restriction apply? Because the language has now departed from the EU and is not even exactly the same as Singapore. We lack the guidance that has developed under those regimes, and there is ambiguity in some of the clauses. Having said that, of course, every democratic society has the prerogative to come up with solutions unique to its needs. So from that perspective, it's good. And the good news is that most people have noticed a lot of these ambiguities and would be submitting comments. And so possibly they would be ironed out in the next iteration.
Yeah. So, with regard to this cross-border data flows and the uncertainties which is expected to be around it, how are you dealing with it as an enterprise level? Because I am sure that you must be dealing with these data flows, and when we don't have a list of countries specified there, so how are you seeing this particular provision of the bill as a challenge for your compliance, or what are the mechanisms by which you are trying to overcome these uncertainties with the bill?
Yeah. So the suggestion would. Yeah. So the approach is typically setting up the standard by adopting the privacy by design standard. Okay. There is a particular objective in terms of what is the data which is being collected, what is the PII data, what kind of controls are to be applied, what kind of life cycle is there. If this is embedded in a structured manner in a proper framework and adopted by any company, it can help to set up baselines which can help you meet a lot of compliances. And there will be certain country specific compliances which you need to look at the differential matter which you need to adopt. So these are the things what we look into, and there are different kinds of sensitive data what the firm internally handles, and the structure goes in depth into it. Secondly, which I would like to add on to it, what I feel is that on the current bill, if we evaluate something of this, the standards are missing. And I think we should learn from PCI standards, the payment card industry standards, the way they are well structured it. Probably we need to come in terms of categories related to how and what kind of standards the data has to be applied, related to healthcare, related to citizen services, related to validation of identity, etc. Once these things come in, probably things will flow in. There has been also an effort to put in a lot of solutions in place, a lot of automated AI-based, analytics-based solutions to identify and decipher the adoption of data, what we do, and the definitions are then validated periodically. So there is a whole in-depth program in which we operate and capture PII data, because there are multiple levels of PII data for us. Employees, contractors, customers, and then there are different industry-specific regulations and norms in which the PII data has to be operated. There are different geographical data spreads in which we operate. So even if I am going from one country to another, the PII regulation changes. How long I am working, am I on a temporary role or I am there for a specific function or change my geolocation, changes the whole definition. And what you do with the past data.
Yeah.
So it's a complex subject. It has to go in and it has to get deeper
Yeah,
into
so
that.
this is why I asked you that question. Like in case of India not having a privacy regime as structured as we have in other jurisdictions. So as a company dealing with multiple jurisdictions, what challenges, like what are the challenges that you face in Indian context? Like you know you are already complying with the international legislations. So
So
in that case,
adopt those practices and follow it inherently as a baseline.
As a
This is
basic-
what we follow. That is the baseline which we adopt. So if any new regulation or compliance comes in India, which differs, at what level it differs, see broadly it will comply. It will be it's there. It's part of that. The only part what we need to do is how is that data handled and what standards are applied for managing that PII related data.
okay. Rajesh, like I would ask you.
Just wanted to add to the previous question. I mean, see, many legislations when they come in, they don't significantly identify the list of adequate countries. I mean, you look at the POPIA, South Africa, the law came in 2013, got effective in 2021. Still, you don't have clearly identified adequate countries published. You look at the LGBT, the same. Yeah, countries like Dubai may have an exception because they are well structured and they adopted the GDPR and replicated to it. And even in China, if you see the PIPL which came into existence, it is a regime which has a huge, severe data localization. But if you look at the PIPL deviated from its normal form and brought in this method where in certain countries, certain scenarios of processing, data can, provided there's a contract in place. So that's where the standard contractual clauses normally comes in. So typically, if you still don't see in the data protection bill the countries with a proper contract, and if you want to tie this up with the relevant provisions of the new bill, we look at, sorry to get into that, but if you look at section 911, which talks about the obligations of data fiduciary, and you can replicate it with 9.4, which talks that every controller and processor has to make sure that there are appropriate security safeguards and retentions put in place. And then there is a section 9.9 which clearly speaks about that in case where there is a processing happening, you need to have a written contract in place. So I think that's the, until you have the ministry identified notification, probably that can really help. And so I just wanted to add to whatever your thoughts. Just an interpretation issue, but it will.
So in like stretching this further, I just wanted to like inquire, like all of you, like whoever is comfortable with, like what do you think that the current draft of the bill is promoting innovation, or in a way with the bill is drafted is a sort of stifling innovation, particularly with regard to emerging technologies and its regulation on the metaverse, blockchain technology?
Yeah, so I just wanted to add a couple of thoughts to the previous conversation. One is that we are calling this a privacy legislation, but the bill doesn't say privacy anywhere.
It says data protection.
I mean, there have been some conversations I've been part of with various people that says that it's more like a data transaction statute specifically and not like a privacy statute. And we see that in the dilution of the sort of various clauses from the previous iteration, right? So I know we framed this conversation in the context of privacy, but I'm not sure if that's what by design, if that's what's happening there. One other thing I wanted to say was my mind now. But sorry, sort of I'll answer your question on innovation. One thing I want to focus on, just picking up from what Jaideep was saying, is the definition of personal data. I think one thing that the 2019 version of the bill did was include the word inferences in personal data. I think we need to realize how data is processed, and my sort of co-panelists are much better at me than understanding this, but it's not processed in a very sort of simplistic manner, right? You're dealing with advanced technologies like big data, right? We've been having a conversation in the country on personal data, non-personal data, right? Because of the reason of the advancement of data processing structures. So I'm just bringing that point in, that purely a consent-based bill may not work, especially if you have principles that are not clearly, explicitly laid down and defined. And I think in ensuring that you remove inferences from personal data, a lot of decisions are made by various types of companies on us every day today when we use all services, digital services that we do. We need to protect against certain decisions that even companies don't know they're making about us, and those are those that may be unreasonable, right? That's actually ensuring self-determination. That's actually ensuring autonomy. That's actually ensuring my choice, right? If we don't make a data protection bill that protects against unreasonable decisions that a company can make against us, I'm not sure if we're looking at a pro innovation bill. But I'll close my comment.
That's why the profiling is already included, because all your behavioral inferences falls within that particular concept.
Jagdeep, like I would stretch this question further to you. Like, given the observation of Shashank which presented to us, do you really think that the bill in this current form is posing challenges with regard to having an informed consent, and for that matter, with regard to processing of data?
Yeah, I think the challenge is more than the entity which interacts with the individual directly. Entities which get personal data not from that individual. There are a lot of ambiguities. For instance, if I give my friends personal data on Swiggy and order a package to them, they are processing it, but my friend has not given consent. And it may not also fall within deemed consent, because deemed consent there are certain specific grounds. They can be interpreted broadly, and there is scope for further regulations on that. But some of these use cases might not fall within. And so if I have to get consent, I have to give a notice, and notice has to be given prior to the obtaining of consent. So how do I screen that data which I obtain? Do I just decide not to take certain data, and in an automated system it becomes almost impossible? The other implication is on the back-end data brokers and data economy. When they process data, they also don't have necessarily the opportunity to get consent. They would have to some extent, rely on the data fiduciary to properly obtain the consent. But again, where that data is derived from a source where the data fiduciary is not necessarily given consent, it becomes a question. So, how this data economy is going to work at the back end in light of this requirement to give prior notice and consent, unless the definition of deemed consent is expanded very widely, because there is scope for that to do so in the regulation. That's, I think, another sticking point for the industry. But overall, I think the sentiment is industry is happier with this iteration than the previous one, obviously, because it presents less complaints.
I would like to tell you the happiness of industry with regard to this bill. Like how industry is happy with the bill.
So only thing which I need to point out and take opinion from both of my legal luminaries is, if I am ordering some food and or sending a cake to a friend on his birthday, what is the inference and what is the level of data or privacy related data, because that's where the definition gets mixed up. Personal data protection and personal data protection which may have privacy implications. So wishing and sending flowers or a birthday cake, and then you have the intermediaries handling that data and misusing that data is there. So I think we need to work on that in terms of services and categorization of services when we look at and what level of data is being processed. Also, second part is, even if that consent or that data is to be held on, what is the timeline? Okay, or you'd look at automatic revocation of that consent if that timeline is there. So some of these things and definitions will come in, and that is what I feel there are too much of technicalities in which the bill has to evolve, and there are too many complexities. I think this is just an attempt to make something, some framework to be in place so that we can have future innovations and controls put in place on data protection.
Yeah, that is right. Like we have a skeleton ready for the bill and for the data protection regime in the country, and we may fill in the details as and when per the requirements of time. Yeah.
Just to add to what Om is saying, I think one important point is that, and I agree, there needs to be standards.
Yeah.
But again, going back to what Apar was saying before, this board, so to say, doesn't have regulatory powers, right?
Yeah.
And we saw the DPAI in the previous iteration of the bill have specific regulatory powers and codes of practices that they could establish. I think it's significantly important for the evolution of data protection, as my co-panelists are saying, and for industry as well, for this board to have regulatory powers. So,
when can you have a regulatory power when you have certain what do you call certain I say certain flesh in that framework.
Yeah.
I think the flesh is missing, and I believe it's an evolution which we are undertaking. In next 3 to 5 years, we'll see a lot of flesh, and it will become regulatory.
the point is that the bill doesn't allow for that flesh to develop.
Shashank,
now.
I would like to intervene here. Maybe like we are having parallel legislations around digital economy coming in, be it telecom bill, we are expecting a Digital India Act. So I assume that we may expect an umbrella sort of legislation coming into existence, say suppose under Digital India Act, I presume, and then they will have an enforcement power there. And because I know there's a like regulatory complexity here, because we have all the laws coming in one after another, and we have to like grasp it and understand the nuances which they offer. So I would like drift a bit away from this PDP bill because it is already under consultation. I would like to see your expectations with regard to Digital India Act or the IT Act, where as we are assuming that it's gonna get repealed or amended for that matter. So how, Shashank, you or Rajesh sir, if you can intervene, then how do you think that Digital India Act or the Personal Data Protection Bill or the other sectoral regulators are going to interplay with each other with regard to enforcement of the laws?
I think that's a very important question. I think more conversation should happen on this subject, and thanks, Deepa, for maneuvering us here. Couple of things are happening. I think, and again, these are signals from the government. We don't have a vision document as there is in the EU. But my understanding is there's a data protection legislation. We're in the public consultation. There's already been one public consultation on the telecom bill. There, the government is saying through the press that there's going to be another version of the telecom bill. Hopefully, that's a good step the government is taking, because there were various challenges which will be the primary focus of the Digital India Act, I believe. So yeah, I would just keep my comment short. I know we're short on time, that we need to think about categorization, look at how the internet works, and we need to have specific rules for different entities, right? Not a one size fits all kind of regulation.
Categorization is definitely is on the way, because even if you look at the data protection bill, it is going to depend on categorization, because see, we have not dwelled on data localization in this protection bill. So I don't think we are going to get off that topic anyway, because that's has been a topic of discussion even by those countries who have not even been open enough to bring that into a legitimate, a legislation standpoint of view. We are going to get, and I'm sure, as Zazang said, that there is going to be categorization where you will have separate, social media is going to be grouped under a separate bucket, and that basically what we can look at like is, from my understanding, we have three models of privacy, right? One, you have the comprehensive model like the Europe, then you have the sectoral model like US. So here we may look like a co-regulatory model where you have a central legislation, and you can have these kind of regulations which can act as a separate code, sectoral code, which combined together will have to become your facet, what you need to handle from a compliance standpoint. And I think there are a lot of places where central government and the board, mostly central government is expected, at least from the first bill there is a deviation, because the first bill I still remember we had around 26 places where central government is expected to make rules, and the data protection authority were close to 28 places it was supposed to make rules. I think here it is carved out, probably it is left to the central government, and I'm sure what has been interestingly spoken about while we compare with other countries, especially in the wake of discussions like adequacy, whether India can get the adequacy and stuff. I think this bill is not going to be the framework that's going to be used. Mostly it will be the MLATs and other trade agreements that is going to decide our position in the market. So I think it's been understood very quite clear. So this bill will be more focused in local growth. And if you can see, even Europe also, Europe used to have that strict regime, but it never stopped data moving out. But today, if you look at, Europe is focusing on many legislation like Data Governance Act, AI Liability Act. Everything is focused on more innovation. So to answer to your question that probably I missed in the beginning, innovation is a concept, and I think this bill also provides more leeway for startups and innovations. But Uh, when you look at privacy, especially data privacy, you're looking and it's connected to one of the facet of privacy, which because privacy has multiple facets. Has it looked upon to meeting the needs of the end data principles? I think that's where it is falling short.
Yeah.
But I think it already has a lot of weapons like right to access and everything,
Yeah.
which definitely people can use it provided they are aware of the requirements. So I think that's going to be the difference in this bill.
Jaideep, now we are discussing as international jurisprudence or international developments around privacy. I would like to ask, like, what are the key takeaways? Like, not the learnings altogether, but the key takeaways that we can have from the global perspective, or the best practices that we can adopt in Indian scenario when we are still dealing with the consultations around digital data protection bill or the telecom bill or the digital India Act for that matter. Like, key takeaways or the good things that we can adopt.
Sure. I mean, I think there's a conscious decision to depart, as we discussed, from uh, some of the global models. We have neither gone towards the GDPR model nor the US sectoral style model. We have the DPDP bill, which is there. We also have the several sectoral regulators like the RBI, SEBI, etc., which lay down different data protection frameworks. Uh, so I think there's possibly a conscious departure from global practices as far as the privacy law is concerned. As far as the Digital India Act and Telecom law, another departure in the draft telecom bill is regulating the application layer under the telecom law and possibly making it subject to licensing and registration. So the global best practice there is to keep the internet open and permissionless as far as the application layer is concerned, and only regulate and license the infrastructure layer. As far as the Digital Markets Act, I think the learning is to keep the to see the holes that are there in today's framework, because very recently we've had the e-commerce rules. There's a policy decision been taken on that. We have new intermediaries guidelines. We have the Competition Act with the CCI taking action against big techs. So those are some of the key issues on the digital age that are already covered under different laws, and we have sectoral privacy restrictions. So what is the gap that the Digital India Act is trying to plug is a big question. My thought is that one area that it can reform is on interception and blocking, where the IT Act framework and rules can there can be more safeguards built into that and a more transparent mechanism.
Like with regard to this Digital India Act and assumptions about it and the protection of consumer and digital data around it, how as an enterprise level you ensure that the consumer data is technically saved and there is some level of data security, or for that matter data protection is assured to your consumers data in that regard from a technical perspective?
Firstly, the act is not out, so I cannot comment on that. Secondly, is that if the baselines are good, so that will form a good building block in terms of in terms of growing on to that part. But there are certain things and where the certain gaps are there regarding how social media is used and misused. We've seen a lot of forms of misuse coming in, and there are pros and cons, and that's where a strong regulatory body is required so that there is no preference. We have seen that in case, I think, on Twitter in terms of how they used to judge quasi judicial body which is not having any authority but acting on that part. So I think Digital Act will cover all these domains, and it will also help for enterprises to frame the rules in terms of how these assets are used and misused. There have been a lot of instances. If you talk about data privacy, individual personal privacy, personal plus privacy has to being targeted to specific social media and cyber attacks, just to malign your reputation, to create a kind of differentiated opinion about certain individuals. You may look at for celebrities now, Now it is coming into certain power individuals and individuals who and their connected families who are there. So a lot of these things I look at, Digital Act trying to help solve, and also especially the takedown piece of, certain content which is malicious to individuals. This thing.
So basically, we can expect that complete interplay or conjoint interplay of these legislations will give us a greater picture around data privacy, because we have to remember this fact: this bill is only data protection. It doesn't talk about privacy in the preamble of the law. So we are saying that digital privacy is the context of the current draft of the bill. So Rajesh sir, I would like to ask, like in a country like ours where internet is still an issue in rural area, like the evolving regulatory landscape, how can it just match up to the expectations? Like my first question, I'm stretching my first question further after this discussion, that what can a regulator do to match up the expectations of the people? Because when coming with the comprehensive iterations, we were not happy. When coming with the crisp iterations, we are not happy. So how we can help our regulators frame policies around these complex issues of privacy and protection?
Okay, so see, any country, I mean, any policy development goes through the thing like what is the basis, what is the purpose, what is the scope that needs to be. If you look at for a rural industry, I don't think data privacy law is of a must. For them, it is the daily bread and butter is that's something which I have learned, and so that becomes much more crucial in sense. But and here where it applies in many priorities is you see that it is applied in the instance of your Aadhaar and other kind of informations which are little bit used more from a political standpoint of view. So not getting much depth into that. I think from a rural application standpoint, if and you know, I don't see much of an applicability to be very precise, and I'm sure the policy also, the law also will not cover to that extent. But what I potentially see that the need, where the regulator need to emphasize, and these are some things which you can potentially, if you look at ICO Commissioner's website or any regulatory data protection authority's website, there's a very clear imparting of education or awareness in terms of what are your rights as a citizen, your rights as a employee. It's been very explicitly carved out. I think that is going to make the big difference to really see how. And second, balance it with the trade, because see, at the end of the day, we talking 1981 convention was primarily about processing of personal data outside, was primarily to promote trade and business, right? You can't have a very strict regime, so you need to balance that proportion, and I think that's going to be the government's probably the attention which you need, because otherwise we are an outsourcing industry, and I don't think we are going to survive, and we will become another case of Greece or any other country which went into almost like a bankrupt.
But there's an exception now for the BPO.
Yeah, so that's what. So that is where I see probably regulations is more focused towards promoting business and trade. Is it really the expectation that was set out in the Puttaswamy judgment? I would like to beg to differ. It's not the case, and apart from that, I think it's more about a stronger enforcement. If you still wanted to bring this law, have the other facets of other sub-regulations connected together, the stronger the enforcement, because to be very precise, everybody should be admitting to this fact. I can't stand, but so you need to have a stronger deterrent. It's a stick or the carrot. The carrot is not going to really help us out. It's going to be the stick, right? So more the harder the enforcement, the more harder its adoption. But needs to balance the interest, because privacy is not for business. If you look at GDPR doesn't bother whether it's a data controller or a processor. It bothers only for a data subject. And that's where every aspect of its provision is addressed to that, and our bill is little bit of a deviations to that. Very precise.
Yeah, so given this expectations of having deterrence, now I would like to pose a question to the panel, like whoever is comfortable with the question. Like we are seeing an emerging technology scenario of, like with regard to facial recognition technology being used in airports, or for that matter, metaverse and the healthcare industry is catering to it. So and we don't have a stronger enforcement, as we are very clear about it, in at least in the recent bill. So how do you see it as a challenge with regard to evolving digitization and evolving emerging technology? So what can we do to balance the situation, that we want to have these emerging tech at one hand and we want to balance our privacy rights as a data subject. At least my privacy should be protected on that virtual world. So what is the way ahead? How can we move ahead in that path?
I mean, just to jump in here and just picking up from Jaideep as well. I don't think we have to reinvent the wheel here, right?
Yeah.
Like there are other countries where FRT and other technologies are being used for even far more years than even us. There are certain mechanisms that they have adopted. I'm going to pick up on the interception point that Jaideep was mentioning. I think that's one point that's missing from at least two drafts that we've seen. We've not seen the Digital India Act, as Om was saying. And going back to the Shri Krishna committee report, the committee was fairly clear that current standards of interception in India are not functioning. So it's fair to say I'm relying on a committee report. So we need to sort of evolve and rethink. Unfortunately, the Pegasus judgment, we thought that something's going to happen there, nothing happened there, unfortunately. But I think we need to rethink a framework for interception. I'm especially referring to the sort of Digi Yatra Airport FRT, which is a state service. I think it's going to be different when you talk about private services, but when it comes to state services, in our view, currently it's operating outside of the purview of the law. There is no law right now that is sort of enabling that provision, and strictly reading what the Supreme Court said, that's not as per law. So I'm just going to stick to that. But I think that various other countries, obviously, I'm not just following the sort of European and sort of Western countries, but even countries in like South Africa and other countries have established certain frameworks to balance this, right? Ensure that you use emerging tech, at the same time you ensure privacy. For example, ensure that there's some amount of judicial oversight when problems happen. So again, we don't have to reinvent the wheel here. There is sort of options available. Everyone's been talking about it going 5 years back, so there's nothing.
Yeah.
UK has for each 9 people you have one camera. I mean, so it's understood.
Yeah.
But it has a very stringent. You raise a complaint to the authority, you will get bogged down onto that. I mean, you will get a case that will be a letter that will be sent to you in 15 days of it, and you will have to resolve, or you need to convince. So they are very stringent in the sense, that's what I said, the carrot, the enforcement needs to be so much that we need to be having that regulating structure in place. Otherwise, it's going to be really tough for them.
Yeah. Hi, Om.
I think if you look at Aadhaar and it getting interlinked, and the best example of Aadhaar is execution of your COVID certificate.
Yes.
I don't think you would get any good example of use of technology for greater good.
Yes.
And facial recognition in a Digi Yatra is for convenience.
Yes.
I have done download because it gives me convenience to just walk through and I don't need to wait. And if people are willing to accept that convenience, then they may use it. People who are not willing to accept or not willing to share, they are still skeptical, may then go into that line. Probably you will have digital divides here and there. And I think it's the adoption of the services and technology at large which provides greater good. There will be flaws. I will not say there will be no flaws in any architecture we adopt. But if it provides that greater good, is something what we need to execute it. And that let the consumers and people, citizens of India decide what's good for them, what's not good for them.
So term which I would say is choice.
Yeah.
So you need to give a choice. As long as you give choice, whatever you do, it beats, because there's an option for the person to choose.
So, at some level, I agree with my co-panelists that obviously we should use advanced technology.
Yeah.
I think where I was coming from is what happens in case there is misuse, right? Not that we shouldn't use, we should use advanced technology. So just want to clarify that.
That goes with it. Now, social media now, you see a lot of misuse.
Yeah.
Just an example for an enterprise, how does it affect?
Yeah.
You see a problem, that problem gets amplified that, we should stop using brand X, brand X, brand X. Are there really Autobots who are putting their opinion, or there are people who are putting their opinion who actually use those products? And it differs. It really kills in terms of, the time, the brand, and that is where we require what you call faster regulations where there is a process in which things are to be addressed. And it can have major impact. somewhere it can be in multitudes of millions in terms of for a brand losing that particular positioning for a particular period of time, because to reach that level again you need to invest so much. So there are enterprises and implications. So it's an evolving situation.
Yeah, like it's truly an evolving situation. Yeah. Okay.
So one question I have for my legal friends. So do we require judges who understand tech better?
Yes.
And I think that is the biggest drawback in terms of when they are designing or commenting on certain judgments. So this is something where we need specialization. Like we need judges who comment on economic frauds need to be specialized. This is something which we need to look in internally in our legal jurisdictions, as to have specializations to target and solve certain issues in hand.
And not only judges, but even lawyers.
Jaideep, you can continue.
Yeah, so the interesting thing is under the draft PPDP bill, just coming back to that, there's a provision to appeal to the High Court from the Data Protection Board. So a lot of these interpretational ambiguities we are discussing would possibly get resolved at the stage of the High Court, and it becomes important what kind of decisions are coming from there, because obviously maybe the first High Court decision will set precedent for the whole country, and then if there is a division of opinion, it may go to the Supreme Court, etc. Obviously, as of today, unless it's a tribunal, there's no formal system to mark cases to more tech-savvy judges. It's based on the discretion of the Chief Justice. And the way the court allocation works today is that there's a rotating roster where judges are assigned different categories of cases, which keeps changing every few months. So yes, it would be interesting. I think, for instance, in some countries abroad, some judges decide only patent cases, for instance. So, but as of now, there's no formalized system for that, and there's no. In fact, if you see today, there's no specialist tech litigation lawyer as well. Just to pick up what Shashank said, the biggest tech cases are argued by the same senior counsels who argue other non-tech cases as well. But obviously there are certain counsels and judges who tend to have a flair for these issues compared to others.
Very quickly, I think we do need, I think I agree that we do need more awareness and training for professionals first, judges, lawyers, other professionals. But I think I've been hearing Rakesh speak about this. Just one point, that the previous iteration of the bill also enabled the DPAI to ensure there is citizen awareness of issues. I think we can have that provision in this bill as well. Like, I don't know what's the downside of having that. So.
Yeah, so like the point well taken, that we, in order to have a like structured and protected privacy regime in the country, we need to start from the very basis that we are trained in that manner. And for that matter, Data Protection Board also has that expertise to deal with this tech cases. Like, so not only the regulators, but also law and technology needs to play out together in order to have a like full-fledged pillar of privacy in place. So with this, I would like to close this session for now, and we can take one or two questions from the audience in the paucity of time. So if you have any specific question to any specific panelist, you can pose ahead.